right now, there is a vast, monumental, chilling effect that is keeping tens of millions of us from speaking our mind, from advocating our causes, from attending protests, because we are afraid of the consequences. You cannot live like that. Claim the First Amendment, own it, use it, stand on it, defend it. And if there are consequences that follow, those are consequences we just have to bear.
Welcome to Reconstructed. I'm your host, Tonga Leslie, and today we're talking about the First Amendment. Let's be honest. Progressives have not always had the best relationship with the First Amendment. When I was in law school, two of the landmark cases we talked about with the First Amendment were Skokie, where the Supreme Court upheld the right of a neo-Nazi party to march with swastikas through a community of Holocaust survivors, and Virginia versus Black, a Supreme Court case where they upheld the right of the Ku Klux Klan to burn crosses as expressive activities. But we have seen a revival of interest in the First Amendment in recent years, when we've seen governmental efforts to squash speech, like in the pro-Palestine movement, and the current administration's efforts to stop what colleges can teach about and what law firms can sue about. Moving beyond specific situations, it's helpful to have a set of underlying principles to understand where the First Amendment came from and how we should think about it as context evolved. Today's guest is going to help us do just that. William Carter Jr. is a professor and former dean at the University of Pittsburgh School of Law, and he proposes the bold idea that to truly understand the First Amendment, you first have to understand the Civil War. I want to welcome Professor Carter to the podcast, and thank you for being with us.
Thank you. It's my pleasure. I'm looking forward to the conversation.
First, I want to just start off with kind of noting that certainly when I was in law school, and I don't think it's changed a lot since then, the First Amendment tended to be sort of a whiter space. I think often the sticks and stones, but words will never hurt me vibe just did not attract many diverse scholars into the space, legal history as well. But you've spent a lot of time in these spaces, and so I'm kind of curious what motivated you to make this a scholarly interest.
So my experience in law school was the same as yours, and I think it is especially acute in the area of free speech, but as you know, it's kind of throughout the law school curriculum, that there's a set of underlying assumptions about neutral principles of the law that, in fact, once you interrogate them, are not neutral, right? And so you start to question, well, why are these kind of the governing principles rather than some alternative set of principles? And the answer is, well, these are neutral, right? And they don't favor anyone. And if we apply them equally, they will lead to just results. But you very quickly learn, of course, that nothing is neutral in the law. It's all a series of choices. And in the First Amendment space in particular, there are a lot of tensions that come to the fore very quickly in terms of competing policy concerns. So, the traditional justification for the strong American tradition of free speech as we apply it is essentially twofold. Who do you trust to draw the lines, and what lines are going to be drawn, right? It is thought that it is better to keep the government out of regulating speech entirely, because allowing it to do so raises the risk that you will get a decision maker who is biased and will apply restrictions on speech to silence criticism or dissent, and that it is better, therefore, for all of us to have a free marketplace of ideas where ideas compete and the best idea wins out by virtue of our choices. And I support that in theory, right? I think that is a reasonable approach in theory, but when you get to the hard cases, it isn't satisfactory in and of itself. So I started thinking about the First Amendment, kind of deeply, just in the last 5 to 7 years or so. In part, it was because I was teaching a class on the First Amendment, so I had to prep and learn a lot of the doctrine. But it was also because I had been writing for a long time about Reconstruction, the law of slavery, and the post-Civil War Constitution. Unbeknownst to me, there is this missing chapter of our First Amendment history that doesn't take account of what was probably the longest and most intense fight over free speech in the history of this country, which was about the suppression of abolitionist and anti-slavery speech. So The traditional narrative of the First Amendment, and I mean both in our law school curricula, but also when you read contemporary Supreme Court cases, is essentially this. First Amendment was ratified with the Bill of Rights in 1791. We then had a pretty immediate controversy over the Alien and Sedition Act passed by the first Congress that outlawed criticism of the president. That statute, although it was never struck down, has lost in the court of history inasmuch as we adopted a robust set of protections that may have lain dormant for quite a while until the early 1920s and 30s when dissenting justices began criticizing the clear and present danger test during the Red Scare years. And then it came to full bloom in the 50s and 60s, starting with Brandenburg, the cross-burning case, and other cases that take a much more stringent view of when the government can suppress speech. You'll notice in that timeline that I discussed, there's a gap of about 80 years, right, from the late 1700s Alien and Sedition Act period all the way up until the 1920s. And what's missing in that gap is the period of slavery, the Civil War, and abolition. For the first, 70 to 80 years of the country's founding, the most intensely debated political issue was not just slavery itself, that was true, but also whether people should be allowed to speak in opposition to slavery. And I have to say, although I've now been a law professor for 24 years, this chapter of our legal history was completely unknown to me. Completely unknown to me.
I'm going to pause you there just to make sure our listeners are tracking because there's so much history. In broad strokes, what I'm hearing you say is we have sort of the First Amendment written around the time of the country's founding and basically laying dormant until relatively recent history, like the past 100 years. But you're saying that actually the first big sustained test for the First Amendment was around slavery and the abolition movement.
That's right. That's right.
And what kinds of challenges were you seeing there?
Abolitionist and anti-slavery sentiment had always been present during the colonial period and during the early founding period. But it really became more public as well as more vigorous in the early 1800s. As slavery started to expand throughout the country, anti-slavery activists and abolitionists started pushing back harder and more publicly. These two movements are colliding. One is becoming more radicalized in seeking the expansion of slavery. And in reaction to that, the other is becoming more radicalized in its opposition to slavery. Around the 1820s, we start to see anti-slavery and abolitionist sentiment really enter the public debate in a pretty much constant way. What we therefore see very quickly is that in the slave states, and interestingly, in the North as well, laws are passed very quickly to punish anti-slavery speech very draconianly. And we also see white mobs simply disregard the law and attack anti-slavery speakers of all races by lynchings, killings, and other things we can talk about. The courts were actually grappling with this, but they didn't yet have a doctrinal framework for saying this is a First Amendment issue. But pro-slavery activists and anti-slavery activists very much talked about this in terms in the public and political debate as an issue about freedom of speech under the First Amendment. And so we don't get a ton of case law from this period, although there is some. What we do get is a lot of statements in Congress, in state legislatures, in books and articles and newspapers and just public conversations about the appropriate limits of free speech on the issue of slavery. And so I think that can be very illuminating in and of itself because I think it was Akil Amar who said, our history and understanding of Reconstruction has essentially become invisible. It's like the person who wears glasses and never stops to think about how they're refracting the light, how they're changing things. Similarly, by not interrogating and really examining this period of history, I would contend we are missing what it represents in terms of how we should understand the First Amendment now.
Why weren't courts sort of accepting these challenges, considering these laws as First Amendment issues, striking them down?
There are probably two reasons. The first and bigger one, of course, is that the language of the First Amendment and what we know of its original drafting history speaks only to Congress and its limitations on freedom of speech. These limitations on anti-slavery speech were mostly as a matter of state law and or private mobs. And so it wasn't thought to be an issue that one could bring a formal legal claim under the First Amendment unless Congress was the actor suppressing speech. The other reason is that a lot of the assumptions in our modern legal culture are just that they're modern, and litigation as the primary tool for vindicating civil rights really wasn't the dominant method that was employed by people who were seeking to advance or to impede progress. That was much more in the legislatures, in the newspapers, and in the streets. There were some court cases, but it was not the default posture that if I'm vindicating individual rights, my first path to do so will be through the courts.
And yet, nevertheless, abolitionists did believe they should be protected by this right, and we're bringing that to the fore. So I want to ask you a little bit about, or a lot of bit, about how that changes post-Civil War Congress, Reconstruction, and how they were thinking about the law in that moment after seeing the Civil War and what came up.
So, what we had from the colonial period through the Civil War was a legal system, including the Constitution, that was shaped entirely in service of what was called the slave power. The idea that there was an all-encompassing, dominating, nationally present commitment to slavery that shaped our economy, our daily lives, and our law. That was our legal regime. So, to answer the question I posed earlier, should the Constitution allow a state to restrict anti-slavery speech? The view of those who were part of the slave power, that is, slave owners and their political allies, would say, well, of course it should. Our entire social order is shaped around this institution, and allowing people to criticize it poses too much risk to the foundations of our society. So that was the dominant frame. Our law serves slavery. There is a lot of debate about whether the original Constitution was pro-slavery or anti-slavery. I can set that to one side because I think what all persons in that debate would agree on is that the law operated in service of slavery, whether that was its intention or whether that is how it was shaped. When we get to the Civil War, many scholars, including myself, have contended that that represents such a fundamental break with that prior regime as to amount to a second founding, a commitment to a new and opposite set of principles different from what had dominated our legal and social culture previously. And so to interpret pre-Civil War constitutional provisions and apply them today in 2026 as if nothing had changed from the original founding moment to now completely ignores the magnitude of the schism that the Civil War created in our society. The Civil War itself, the actual military battle, was of a magnitude that is hard to really conceptualize. And two facts I have found can help make it more concrete. The first fact is this: more soldiers died in the Civil War than in any other war. That's pretty well known. What's less well known is this: almost half of all Americans who have ever died in war died in our Civil War. Nearly half of the people ever killed in every war this country has ever fought were killed on American soil in the Civil War. So that's one thing that kind of brings its magnitude to bear. Here's the other. Approximately 500,000 people died in the fighting in the Civil War at a time when the country was 1/10 of its current size. What that means is if the Civil War were fought today, approximately 5 million Americans would die on American soil. That is a scale of destruction that unavoidably touched every aspect of society, economically, personally, etc. So that's kind of one thing that makes clear the magnitude of the break of our pre-Civil War nation and our post-Civil War nation. But the other is more strictly legal. As I mentioned before, if the pre-war Constitution was devoted to the service of slavery. Then the post-war Constitution, its framers said in adopting the 13th, 14th, and 15th Amendments and the civil rights statutes that accompanied them, would do exactly the opposite. Our second founding would create national power that is at least as strong to promote equality as was the national power to promote slavery. And so it inverts entirely the first principle of the Constitution, as Senator Charles Sumner said. Henceforth, that is, after the second founding, the Constitution should be interpreted forever in favor of human liberty, the exact opposite of the way it had been interpreted previously. So if we understand that the baseline interpretive principle in the view of those who wrote and spoke about and debated the post-Civil War amendment has changed, that then affects not only prospectively how we interpret those new amendments, the 13th, 14th, and 15th, it also affects retrospectively how we should interpret the Constitution that came before. And that includes the First Amendment, both from personal experience as well as contemporaneous knowledge. The drafters of the post-Civil War constitutional amendments believed that protecting the freedom of speech, that is, correcting the prior suppression of anti-slavery and abolitionist speech, was one of the single most important things that our post-Civil War Constitution would do. Senator Charles Sumner was beaten nearly to death on the floor of the Senate in the 1850s for making an anti-slavery speech. Representative Lovejoy's brother, Elijah Lovejoy, who was an abolitionist publisher, was murdered and his printing presses were burned for engaging in anti-slavery speech. They spoke in the debates around the 13th and 14th Amendments about the various state laws that they said made a mockery of our First Amendment. And indeed, I believe this was Representative Stevens who said that if we are going to hold that state laws suppressing anti-slavery speech are constitutional, then we may as well burn the Constitution because it means nothing. They had fought a battle for decades to preserve the right of people, sometimes themselves, sometimes others, to engage in pro-equality speech. Having now won the war, it was of paramount importance to them to embed that principle in our Constitution going forward. And so in interpreting the First Amendment, I'm not suggesting that the freedom of speech has become less important. What I am saying is that if we are to be faithful to the vision of the second founding, it should be interpreted in light of what its new goal was, which was to promote freedom and equality.
I wonder if you could say a little bit more about how these efforts to target abolitionist speech were actually playing out. And another thing that I don't think we've touched on directly, but there was speech targeting abolitionists, but you also talk about the speech of enslaved people as well. Could you talk about that and just what and how those laws and measures shape people's lives?
So there were specific state laws that would say things along the line of this. Because the circulation of anti-slavery sentiment has a pernicious influence on enslaved persons, that is, if we create an atmosphere that is anti-slavery, then people are more likely to oppose slavery. Some of those people are the enslaved themselves who may seek to escape or rebel. We, therefore, declare it to be the policy of this state, South Carolina, Georgia, etc., that such advocacy shall be punishable. In some states, it was punishable quite severely. For example, in North Carolina, it was punishable by death on the second offense of circulating anti-slavery material, and punishable by corporal punishment and a term of imprisonment for the first conviction. So sometimes we would have very specific state laws that just essentially singled out in what today would be called viewpoint or content discrimination, a specific subject, slavery, and said that's off limits for criticism. There's also kind of a less formal but still legal method by which slave owners and their allies would use the force of law to suppress anti-slavery speech. which is that government officials would be personally involved in some of the mobs and vigilante groups that would attack anti-slavery and abolitionist speakers. There are numerous cases, some of which I referred to earlier, where people were lynched, murdered, their property was destroyed, they were stoned, they were beaten for engaging in anti-slavery speech, and local governmental officials would actively participate in such actions quite often. There was also, of course, the use of purely private violence, whether one-on-one or by organized vigilante groups like the Klan and other terrorist organizations that would specifically target abolitionist writers and speakers, and would then be granted immunity and not prosecuted for engaging in those acts of private violence. So there were multiple layers in which the legal system directly or indirectly participated in the suppression of anti-slavery and abolitionist speech.
You did mention that it just wasn't as part of the ethos then as perhaps it is now, for better or for worse, the idea that you're going to run to the court and get your validation there. And so how were abolitionists responding to this, I mean, both the laws and the private actions? And do examples come to mind of how people were still trying to get the messages out despite this framework?
Just to clarify one thing, I keep saying abolitionist and anti-slavery advocates because those were actually two different groups. Abolitionists were those who believed that slavery was not only immoral but also unconstitutional, and that the federal government had an obligation to end it nationally. Those were, at the time, kind of the more radical end of the spectrum. The kind of mainstream in the 20s and 30s was actually not abolitionist, it was anti-slavery. And it was to oppose any expansion of slavery into free territories, but not to necessarily abolish it. What's interesting about that is this: like all who would oppress other people, pro-slavery advocates were essentially cowards. So even that very mild and pretty conservative view that would just limit slavery's expansion but let it continue to exist where it did was seen as a radical provocation, something that should not be allowed in the marketplace of ideas, because enslavers were afraid that even that milder view, let alone the more radical abolitionist view, was a debate that they couldn't win. They refused to fight it in a fair fight. And there's a lot about this in the framing history of the 13th and 14th Amendments. Even as to anti-slavery speech, it was seen as so provocative as to not be permissible in the public debate because enslavers and their allies did not wish to debate it. What did those who were advocating abolition, or at least limits on slavery, do in response? They did sometimes turn to the courts, right? And I don't want to overstate it, right? Certainly there was litigation in this regard. There just wasn't a whole lot of legal doctrine at the time to rely on in that sense. The other things they did were the following. They pressed Congress to not only abolish slavery, but to protect anti-slavery and abolitionist speech. They filed numerous petitions with Congress, which, by the way, because enslavers had the upper hand in Congress, led Congress to adopt a gag rule that prohibited any floor debate of anti-slavery petitions. So there were thousands and thousands of petitions flooding Congress, to the point that the allies of slave owners simply prohibited any debate, even in Congress, of the petitions. Another thing they did was they stood their ground in kind of a very concrete sense on the streets. That is, they would continue, even after mob attacks, to make second and third and fourth appeals in favor of abolition in places that had slavery or that did not. So there's a famous speech by Frederick Douglass regarding freedom of speech that he gave in Boston in, I want to say, 1860, which was his second speech on the subject, because his first one a few weeks earlier had been disrupted when a white mob rushed the stage. And he came right back, as did people like Elijah Lovejoy, who I mentioned was eventually murdered. The Tappan brothers were two wealthy white abolitionists who also had abolitionist printing presses, and their presses were destroyed more than once, and they rebuilt them and continued to advocate. I could give other examples as well, but these people were not afraid to speak. One of the things we might want to talk about is, what does that look like today? I would say the level of courage on display at that time can be instructive for what may be necessary in our current time, but we can talk about that later. The other thing, though, that abolitionists, particularly more radical abolitionists, did, in light of the suppression of even the milder anti slavery criticism through very brutal private means as well as very draconian legal measures, is this. They said that convinces us that working within the system simply is not going to change anything. They won't even allow us to argue against slavery. What makes you think they're going to abolish it if they won't even tolerate criticism of it? And so that led them to adopt a different form of opposition or a different way of getting their point across, which was through violence and armed resistance, right? So Nat Turner and Denmark Vesey, and of course John Brown, and many others believed that relying on what abolitionists at the time called moral suasion. That is, that by pointing out and speaking vigorously about the evils of slavery, we will persuade a majority of our fellow citizens to abolish it through the democratic process, was simply never going to happen because their voices would not be heard. I'm conflicted about that third path. I don't personally believe in violence as a form of political change, but I do understand it.
You mentioned this sort of the schism between the radical voices and the moderate voices, even in that time. And some have also written about how even in the northern states, people were not always completely supportive of abolitionist speech. Could you talk a little bit about that?
Yeah, there are many examples of that, which I think can be surprising to people. Because again, our historical narrative is kind of flattened to a caricature of the reality of the events, which were often nuanced and detailed in ways that we don't learn or fully absorb. In the North, not only was there not a majority in favor of the abolition of slavery in the South, but in fact, abolition and anti slavery sentiment were affirmatively disfavored and attacked in the North. When abolitionists were sending streams of their writings and pamphlets and anti slavery materials into the Southern states, those Southern states, as we already talked about, undertook various legal and extra legal ways to suppress them. What they also did was to write to their political colleagues in the North saying, hey, you, New York, should outlaw anti slavery speech there. Because if they can't produce it, they can't distribute it. And in fact, some northern states adopted some such laws. Here's one that didn't. New York. Governor Marcy was asked to urge the legislature to adopt laws prohibiting the production of anti slavery materials there. And he and the legislature declined to do so, but not on principled or constitutional grounds. The legislative debates explicitly say we feel no need to adopt such laws because our private citizens will suppress such speech on their own. They said white mobs will do this work. We don't need those laws. And they did. Probably the most dramatic example was the anti-abolitionist riots in the 30s in New York City, which were close to a full week of lynchings, lawlessness, and violence perpetrated by supporters of slavery, targeting at first known abolitionists like the Tappan brothers, who I mentioned earlier, but then just devolving into a full-on race attack on anyone who's Black or in the company of Black people. And so in the North, abolitionist and anti-slavery speech was generally not very well received at all. There were exceptions. Vermont, as I recall, actually adopted a law doubling down on its protection of freedom of speech under the state constitution and said abolitionist speech is fully protected and will be protected in our state. But it's a misperception that the North was some sort of safe haven for this type of speech. Indeed, as I mentioned, Frederick Douglass was nearly murdered by a white mob in Boston, which is about as far north as you could get. So the environment for this type of speech was precarious and dangerous, right? These speakers were not lacking the courage of their convictions by continuing to speak.
Certainly before the Civil War, you couldn't really say that there was an abolitionist majority in the country, and even in the North, it's kind of tenuous. And yet you still have your conclusion that by post-Civil War, the Reconstruction Congress has the will to kind of endorse this pro-liberty, anti-slavery message and take it out. And so, yeah, how do they sort of arrive to feeling like we're ready for such a monumental change when that wasn't the vibe pre-war?
It's really interesting when you study this period of time. There was almost a Newtonian equal and opposite reaction thing that leads to a majority of the Republican Party post-Civil War adopting this very robust view of freedom of speech. For the first 50 or so years, as I mentioned, from the original founding to the 1820s and 30s, the mainstream anti-slavery movement was actually quite moderate to the point of being conservative. The mainstream position during that period of time was this: we oppose the expansion of slavery to places where it doesn't exist, but we deny the power of the federal government to abolish it in places where it does exist. And we believe the best solution to our race problem is for blacks to either voluntarily or involuntarily be deported. The expatriation movement was actually a cornerstone of moderate anti-slavery. So that's where the center of gravity is. As we get to the 1820s, a couple of things happen that move that center of gravity. One thing is this: slave owners and their allies start to adopt more draconian laws that further, if you can imagine, further oppress and suppress enslaved persons. Because during this period of time, there is increasing concern about slave rebellions, in part because of the examples of successful slave rebellions elsewhere, like in Haiti, but also because of the example of unsuccessful but very dramatic slave rebellions here. So as the population of enslaved persons grew and their centrality to the economy and daily life in slaveholding states increased, there was a corresponding rise in fear of either organized slave rebellions or individual acts of violence by slaves against their owners. That then led slave states to adopt stricter laws regulating slavery and prohibiting anti-slavery speech. So they take a more radical position. What that does is it convinces some significant portion of the moderate anti-slavery movement that, okay, the defenders of slavery, in fact, are never going to be satisfied with just leaving slavery as it is in the states where it exists. They're going to begin pushing for further expansion, either in the newly opened territories for them to become slave states if they're admitted as states, or to further entrench their rights in non-slave states through, for example, very aggressive interpretations of the Fugitive Slave Act that would give them an unqualified right to seize any black person in Vermont, Massachusetts, Pennsylvania, who they claimed was a slave. This is a case called Prigg versus Pennsylvania. And so what the so-called moderates see is that the forces of slavery are not going to accept the status quo. They're going to continue to push, which then kind of further leans them toward the more radical abolitionist end, because they believe there's no accommodation that the South is ever going to accept. So that's one thing that creates a groundswell. The second thing that creates the groundswell that culminates in a majority to be in favor of protecting abolitionist speech and pro-equality speech after the Civil War is that we had not only just fought a civil war, but these framers said always had a legal regime, and they singled out the Supreme Court specifically, that has only ever served slaveholders. We cannot rely on the law alone to be the guarantor of equality. What we also need to do is for those who argue in favor of equality to be able to mobilize public opinion in their favor. The courts will not save us, and the legislature will not save us because it never did before. We have this very brief window, right, where abolitionist philosophy is the dominant philosophy in Congress because the South was no longer represented after the Civil War, or the portions that were occupied by a Northern military government. So they had this brief window where they wanted to bake in the kinds of protections that would allow the advancement of equality and freedom, even if the courts and the legislatures were not inclined to do so on their own initiative. The radicalization of the pro-slavery movement leads to a backlash among the anti-slavery movement. And serendipitously, there's this moment where that more radicalized abolitionist segment is the one holding the power.
And now we've got time to circle back, and this is one thing I've really admired in your scholarship itself, because we've been telling sort of the political story, which includes the people who can participate politically, right? So mostly white citizens, some free blacks like Frederick Douglass having a huge impact, and yet the people this is sort of about, in a sense, often did not have political rights. Black folks weren't considered citizens even often when they were free. And one thing that you also put forth as an argument, which I think is interesting, is that even as we interpret the Constitution, these voices should be at the table and they should be given weight as much as the folks with formal power. So I'd love if you would talk a little bit about how enslaved folks were thinking about freedom of speech, given so many things that were stacked against them, but how were they conceiving of it through the Constitution otherwise, and also how were they attempting to use it? Or in what ways were they engaging with that pre-Civil War?
Yeah, no, it's a great question. And it's what has occupied a lot of my writing, as you mentioned, over the last half decade or so, thinking about bottom-up constitutionalism, right? And in part, I think about that because it's something I believe, right? I believe that all of us can claim a stake in constitutional meanings, a determination. But in part, it's also strategic, given that originalism, so-called, is the coin of the realm right now. When someone says to me, hey, the framers thought X, I stop them and I say, wait a minute, which framers are you talking about? You're talking about the ones in 1787, 1791 who wrote protections for slavery into the Constitution? Or are you talking about the second founding's framers? Because those are two different groups of people with very different predicates. So too, I would argue that if, for better or worse, the coin of the realm right now in litigation is originalism, then let's do originalism, but let's really do it. I am unafraid of originalism as a tool. It's just a tool of constitutional interpretation. So my challenge to those who call themselves originalists is this. Okay, if the original public meaning, for example, is your preferred flavor of originalism, that holds that what is controlling is what members of the general public would have understood a provision to mean. You know who were members of the general public? The millions of slaves who were held in this country. And yet, I somehow never see their views, their experiences, their interpretations as part of the evidence that originalists look to. So in part, this work is just a challenge to originalists. Do you want to do originalism? Then let's really do it. It is important, I think, to understand before I go directly to your question, the role of enslaved persons in American society. We all have a sense of economically the value both of their bodies and their labor. We have a sense from the various laws that we talked about how the legal system promoted slavery, including the Constitution. What's probably less transparent to us, given the distance in time, is what was the lived experience of being a slave. And it's not something I can honestly imagine. I just can't. It's so alien to me that I won't pretend that I can say, I can imagine myself in that situation. But I don't have to imagine it because, in fact, many slaves did leave behind their recollections of their time in slavery. Some of them did so through formal slave narratives, which most of them were either written or co-written with white abolitionists because those were the ones who had the money and connections to get things published. There are some self-published ones, though. But whether self-published or published in combination with abolitionists, they're a very rich source of insight into the lived experiences, the aspirations, and the views of people who were living in slavery. Quick shout out to the University of North Carolina's online slave narrative archives, which, if listeners are interested in reading this stuff firsthand for themselves, is all online. And a second quick shout out to the Schomburg Center for Black Culture in Harlem, which has a magnificent collection, both physical and digital, including slave narratives. When I first started looking into these first-person slave narratives, because I wanted to find a source of what I'll call bottom-up constitutionalism, I was shocked at how often these slave narratives talked about issues of law and constitutional law. Granted, I'll say again, it's a subset of those who managed to get their narratives published. I cannot say that that is representative of all enslaved persons, but for those who did get their slave narratives published and circulated, there is a really surprising amount of discussion about their understanding of what the law meant and how it should protect them but failed them, and a lot of discussion about how the Constitution had been perverted in service of slavery. It is not rare to come across. I didn't have to go digging. I would just flip through and read, and along the way, in describing, for example, the nature of their labor on the plantation, they would then describe an interaction with their slave owner where they were beaten for, I don't know, failing to disclose some information that the slave owner thought they should disclose. And they would lament the fact that the law did not protect them in the use of their voice.
One reaction I could see people having is just like, obviously, this whole law and system was never meant for me. It seems absurd for someone who's being held in bondage legally, and they know that, to still identify with and make this claim and be writing it. Why do you think that is, that there's still that appeal and some level of connection to law?
I think there's two reasons. And I wish I could bring to mind the slave narrative that says this. It was by someone who, after they gained their freedom, later became a prominent abolitionist. It was not Frederick Douglass. I would remember that. It might have been kind of one of his contemporaries who said this: "We have little else left to appeal to. We don't have force of numbers. We don't have weapons. We don't have a majority of public opinion on our side. And so if we're going to maintain any hope that our condition could improve, the law is a thing that, at least in theory, a person should be able to invoke for their protection, even in the face of a majority that seeks to oppress them." Now, legal realists and critical legal scholars would say, now as then, that is unrealistic. And I'm not a crit, but I'm kind of adjacent to the field, and so I get it. But I'm saying that when you read their slave narratives, when people talk about why they're appealing to law, they often explicitly note because it is the only source of authority that a slave possibly could benefit from, because everything else is turned against them. There's a second and deeper reason, though, which I won't belabor, but it's basically this. Even for people who are oppressed, our society is suffused with Enlightenment ideals of Lockean theory about natural rights. That is to say, that we each, as individual human beings, come into the world with a certain set of rights. Those rights can be stripped from us by anyone who has sufficient force, right? Whether it's the government or another private person. But that does not make such stripping lawful. And so I should be entitled to reclaim those natural rights, but for the wrongful conduct of someone else. And oppressed peoples don't believe that any less than people in power. In fact, sometimes they believe it more. It's a kind of secular faith, the belief that there is some hope, some possibility for betterment of our condition. So at least that's my read on why, rather than turning to cynicism, they would still retain some hope in the law. As I mentioned earlier, the most radical wings, though, of the abolitionist movement would in fact say it's not cynicism, it's realism. The law is never going to serve you unless you seize the power to make it serve you.
You're going through these narratives and you're seeing them frame their injustice in these legal terms, in these constitutional terms. Can you just say a little bit more about what they were saying about freedom of speech in particular?
Yeah, it's really revealing. And I claim, no better prior knowledge of this than anyone. It is literally that I just sat down and started reading slave narratives. And it is revealing how often the subject of freedom of speech comes up. The belief that comes across in many of the slave narratives that I've read with regard to freedom of speech is this: if given an opportunity to make our case to the public and to argue about the immorality and illegality, in our view, of our enslavement, we will win. If we can debate this on fair footing, we will win. And that is why slaveholders are fighting so hard to suppress free debate, because they know that. And so there's a lot, quite a lot, in multiple slave narratives where they say, just give us an equal opportunity to make our case, right? Get rid of these state laws that engage in viewpoint discrimination by favoring pro-slavery speech and disfavoring anti-slavery speech, and we believe that we can win. They also talked about their experiences, though, with the denial of freedom of speech in extra legal way, but one that was still equally impactful. So, as most of the listeners will know, it was unlawful in the slave states by the early 1800s to teach an enslaved person how to read or write. The slave states' slave codes imposed incredibly harsh penalties on anyone who taught a slave how to read and write, once again, including the death penalty for doing so. The slave codes also prohibited the assembly of more than five, I think, under most of the slave codes, enslaved persons without white supervision because they could be plotting insurrection. And so it infringed what we would think about today as the freedom of assembly when infringed by the government. It also prohibited, by the way, gatherings for religious purposes outside of the supervision of a white person. So that raises kind of the religious liberty side of freedom of conscience. They were routinely brutalized by their owners for being perceived as acting as insolent. And so there are many slave narratives that describe, either by the writer or by witnessing someone else, the astonishing brutality that was imposed on slaves who were perceived as being insolent or talking back to their owners. The mutilations and very severe beatings would be imposed for being perceived as insolent. And it went even further than that. The nature of slavery, they say in their recollections and narratives, was more than enforced labor theft. It was more than that. It was more than whips. It was more than shackles. It wasn't just about the body, it was about the mind. Slavery was an ideology which required two things: to be sustainable in a country founded on Enlightenment ideas of inherent natural right. The first is that it required, as some would say today, othering, treating as outcasts, treating as what Dr. Orlando Patterson calls social aliens from our civil society, enslaved persons to render them sufficiently different and other that our society at large is willing to tolerate for them conditions that we would not tolerate for the rest of us. The other thing, though, that it requires is to dominate not just the slave's body, but their mind, their spirit, to render them a chattel, in fact, as they had been rendered in law. And so there's one particularly striking slave narrative that I recall off the top of my head where the author talks about how he was beaten severely by his owner for contradicting some other white man's word. And at the end of this horrific beating, the owner raises up for one last strike of the whip and says, "By God, I will teach you I am not only the master of your time, but of your tongue. I own all of you." And to again quote Dr. Patterson up at Harvard, the essential nature of American slavery was that the slave owner had not only the right to use the slave, but to use him up, to use all of him, even to the point of destruction, including all of their mind and spirit and free will and autonomy. And so that combination, creating a perceived inferior class and seeking the complete domination of that class, not just the extraction of their labor, were the key foundations of slavery. And slave owners knew it, and they enforced it, and enslaved persons were aware of what was happening. That's why the subject of freedom of speech comes up so often. Whether they say the words First Amendment and freedom of speech, or whether they recount stories like the one I just offered, it is valuable evidence in understanding, in my view, how the Constitution should be interpreted post-Civil War. So just to return to one point very briefly, our First Amendment doctrine, like all the rest of 14th Amendment doctrine, holds that it is only state action that violates the Constitution, active participation of governmental officials. For an enslaved person, the primary source of the suppression of their free speech was not the government at all. It was their fellow man. And so shouldn't that lead us to rethink the kind of very strict and artificial binary of state action versus private action that the court has implemented? Is one way in which this can cash out.
After the war, people understood that slavery had been this huge confrontation over free speech, that it was time to do something different, and the ramifications of bringing the government and Congress and the courts to bear in a totally different way. I'm kind of curious why this narrative is so buried. If you have thoughts on that, like this, it's nowhere present in anything I've learned in law school. It's not present in even in the civil rights movement, when I think a lot of those cases do have to do very significantly with free speech. They're not talking about this. Could you offer some thoughts on why that is?
Yeah, I can. And I will say there's probably more than one cause. One is that that history has been intentionally suppressed, right? Not unlike our current moment, where we see the President of the United States seeking to wipe out Black historical memory. That was actively done during what historians call the lost cause period of historical research. So around the Gone with the Wind era, right? This idea that there was a noble war fought by rebels that they unfortunately lost and that slaves were happy and that our system is now worse off. That was called the lost cause narrative. And that was so dominant in academia, just as one example, that you could lose your job or at least not get tenure if you tried to write anything that was inconsistent with that narrative. It wasn't until the 60s when people like, a young generation of scholars like Eric Foner, Orlando Patterson, many others, started reviving the real history of our slave regime and our post-Civil War constitutional era, that we could then see that again. But here's the thing, though, that now has been kind of revealed and excavated. Again, just to be clear, though, there are ongoing efforts to suppress it. And so I am worried we are going to enter another lost cause period where scholars and advocates and teachers are either afraid or unaware of this information, and it again becomes invisible. But it is visible right now. So if it's visible right now, why don't we use it? Well, here's a couple thoughts. One is that if originalism is the coin of the realm in our courts when it comes to constitutional interpretation, then it's very much a results-driven originalism, right? The reason why originalism seems to always lead to conservative outcomes is because the people applying it are only conservatives, or at least a majority. And so they're not looking for evidence that contradicts the outcome they wish to reach. This is what Professor Robert Sy has called the difference between activist judges, which have always existed, and movement judges, which we have on the bench now. People who essentially see themselves as the judicial wing of a single political party. They are motivated to get to a given outcome. They are aware of all this other historical evidence and are making a purposeful choice not to address it. Then the third thing I'll offer is this, and it's going to sound like it's a criticism, but it's not. Part of the reason why this constitutional history isn't visible in our jurisprudence is because it isn't used by us, and I mean both advocates and activists. We're unaware of it, even if it's available, but we therefore don't use it, and therefore it doesn't make its way into cases. If litigants don't bring things up, right, there's no way for things to enter into our jurisprudence. So I think it's really a combination of reasons why it's largely been overlooked. I will say, though, as I've told you privately, shout out to you and the Douglas Collective, right? Because that's one of the ways in which this material will make its way into our jurisprudence by increasing just public awareness of it.
Well, thank you for the shout out. One question that always comes through scholarship, and I think there's the inherent value of just knowing, understanding our history, understanding these principles, but people get to the so what? They're like, well, don't we have a wonderful First Amendment now, however we got to it? So would things really be different if we were looking from the perspective of this ethos centering enslaved folks? And so I kind of pass that to you. Like, are there areas of either the law or just the way that we look at free speech that you think would be different if we kind of adopted that vision more deeply?
I do. So I'm going to give you a yes and I'm going to talk about the and before the yes. So here's the and. Even if that criticism is right, even if nothing changed in First Amendment doctrine, I and many other scholars have contended there is still a value to excavating, exploring, making visible, and taking seriously the people who had the lived experience that provided the foundation for our constitutional structure through their exploitation and who have previously been erased. There is a value in seeing and knowing and naming that is a value that's separate from whatever outcome it may create. Part of the reason why we fight today is we are inspired by those who fought before us. The fact that we may not win our fight is only half of the reason why it's important for us to know the battles that came before. So there's that. But I do think it would make a difference, at least in some doctrinal areas. So I mentioned one, the state action doctrine. You cannot read and fully engage with the narratives that describe the experiences of enslaved persons with power and conclude that the only form of power that should matter constitutionally is governmental power. That is just completely insupportable. It's insupportable anyway, by the way. We can talk about state action doctrine more generally, but even if you were to accept it as hypothetically plausible, the accounts of enslaved persons make it implausible. In fact, the accounts of the second founding's framers, who weren't themselves enslaved, are pretty clear that the state action doctrine is not well grounded in history or law. So that's one area. I think that at least certain forms of coercive suppression by private actors of another private person's freedom of speech would absolutely fall within the ambit of the First Amendment if we take this history seriously. That's one area. Conversely, though, there are some areas where the court's doctrine has become so abstracted from the circumstances that motivated the adoption of both the original First Amendment as well as how the post-Civil War interpretation changed it, that engaging with this period of history can debunk and disprove some of these extreme, in my view, perversions of the First Amendment's meaning as part of our Constitution. So I'll offer you two examples. This one's not original to me. Many scholars have written this. The way that the First Amendment operates right now is as a trump card. In fact, there's a great article by Professor Jamal Green at Columbia called Rights as Trumps. So right now it is, if you have a First Amendment claim and you are successful, it therefore trumps whatever other values or concerns may be at play. So unlike some other legal systems whose constitutional adjudication more explicitly balances values that may be in tension in a given case, ours doesn't. It is zero sum, winner take all. If you have a First Amendment right, therefore nothing else matters. But as many scholars have suggested, the First Amendment is just one part of an entire constitution. We shouldn't be interpreting the First Amendment in isolation. We have to interpret it in light of all of the other competing values and vice versa. So some of those competing values are equal protection and due process and being free of the badges and incidents of slavery, et cetera, et cetera, et cetera. And so employing this history could lead us to have a more fulsome, balanced, contextual understanding of freedom of speech, where, for example, Brandenburg burning a cross at a political rally, maybe that's still protected. Maybe it is, right? But there would be no question that directing a burning across at an individual is not protected. And that's a case called Virginia versus Black. That would be one effect, in my view. The other effect, I think, that comes to mind immediately if we were to incorporate this history into First Amendment doctrine would be in our understanding of hate speech. And so I'll just say a little bit of a word here. Over the last decade, I have been actually increasingly concerned and have said both publicly and privately that progressives who began to move very quickly to abandon the goals of freedom of speech and due process in service of admittedly righteous causes were making a mistake. Because by undermining those foundations, which have been the two things that oppressed communities, and not just Black people, but the LGBT community, women, and others, have used to self-advocate for protection of their rights through the democratic process, we are laying the groundwork for that to be turned against us, which we are seeing right now. And my entire case comes down to this. The radical right, notice I did not say conservatives, the radical right is better at oppressing people than we are. If we leave that tool on the table, they're going to use it and use it well. It is what they do. And so I have been alarmed at seeing some of my progressive students, friends, and colleagues So quickly just say First Amendment doesn't matter, who cares, right? If you say something that is offensive or hateful, yes, you should be punished. And I just worry about how quickly that proposition can be turned, and we are seeing the fruits of that today. But there's a more nuanced view that, again, I can't claim credit for, but I can claim being inspired by, particularly folks like Mari Matsuda, Richard Delgado, James Foreman Jr., who have been writing for decades about the fact that not all hate speech is created equal. The First Amendment need not tolerate you screaming a racial epithet at me in order to also tolerate someone criticizing affirmative action, right? This is the idea of words that wound, as opposed to offensive words. And right now, our First Amendment doctrine just treats them exactly the same. They're all always protected. But that can't be true because we already have in other areas speech doctrines that treat certain forms of speech not as speech, but as acts. Treason, harassment, all kinds of other things that are committed through verbal or written communication are just deemed outside the pale. And yet, in this area, this one area, when it comes to racial hate speech, we say, ah, no, it's fully protected. The risks of suppressing any of it outweigh the benefits. And I believe that that's another area when understanding, and this is both true of the Reconstruction framers, I mean, the representatives and congresspersons who adopted the post Reconstruction Amendments, as it was of enslaved persons and their allies. They did not believe that the Constitution required the government to give equal favor to the speakers advancing equality as to the speakers opposing it. Okay. Now, they were not arguing we should suppress those who, for example, believe slavery should exist. They're not arguing for leveling down. They're very much arguing for a leveling up, right? Give me an equal playing field and I will fight. But give me the equal playing field. And so, this idea that there is some neutral principle that justifies treating all hate speech exactly the same and always protected by the First Amendment is just contradicted by the framing history post Civil War.
Okay. I want to briefly ask you to touch on one other area. Even now, there's sort of, I think, the band of included people, right? Like we have our conversation of citizens, and you've talked about especially incarcerated folks and immigrants, and the way that the First Amendment does or does not extend to those communities. Could you say a little bit about that and how we might think about those invisibilized people?
Yeah, I will. So, at a theoretical level, the current legal doctrine is that although the First Amendment presumably would apply to all persons, since it is actually the 14th Amendment right to due process that includes the right to freedom of speech vis-a-vis state regulation, not all persons' speech rights are equally protected. And the reasoning is that you have to be part of our political community in order to have the fullest level of constitutional protections, including speech protections. And people who are incarcerated during the term of their incarceration are outside of our regular civil society, right? They are suffering a kind of civil death during the period of incarceration. And people who are non citizens have rights on a sliding scale that depend on the depth of their affiliation to the country, but they're not necessarily the same as the rights of a citizen.
Hmm.
That very premise, I believe, flies in the face of this historical era of constitutional thought that we call the Second Founding. The idea that the law can make any person an outcast, that is part of someone who is cast out, which is the origin of the word, from civil rights, is the literal opposite of what the post-Civil War Constitution both was intended to mean and what it actually says. This is Justice Harlan's dissent in Plessy, right? And I know it's been perverted to stand for abstract colorblindness by Justice Thomas and others, but if you read it, he says, "We know no caste here. Under our Constitution, there is not an in-group and an out-group when it comes to full civil rights protections." And he was writing this 30 years after the end of the Civil War. This was not ancient history at the time. So the idea that immigrants, because of their non-citizen status, or incarcerated persons because of their status as incarcerated, or any other cognizable group is entitled to less than the full panoply of civil rights guaranteed by our Constitution is completely unsupportable by any originalist legal theory that honestly grapples with the facts. And yet, it's what our courts and our court have accepted. So I wrote a shorter article about the speech rights of incarcerated persons. There are very few and far between. We accept that. Same with regard to non-citizens, and we're definitely seeing that playing out right now with targeted ideological deportation. And I'll just say one thing on this because it reminds me of something again from the debate over slavery and abolition. Within the white abolitionist movement and the black abolitionist movement, there was a lot of common ground, but there were some divisions, right? Some things by virtue of social position or just the nature of how you related to the issue of slavery, that were some points of cleavage between black and white abolitionists. One of them I learned in a great book by Jane and William Pease, I believe it is called They Who Would Be Free, was this. Black abolitionists, whether former slaves or free blacks, very much took the position that, yes, we must fight to end slavery, but for us, it is not purely a moral imperative, it is not an abstraction. And one well-known black abolitionist, whose name I can't bring to mind right now, said this. How do you, speaking to a white abolitionist, how do you think I can imagine myself free when millions of my brethren are enslaved? For me, it's not merely ideological. It's not merely about them. It is not altruistic. It is a part of my own lived condition. As long as people like me are enslaved, I have no meaningful freedom. In our present moment, I very much feel that same way with regard to incarcerated people and their free speech rights and non-citizens and their free speech rights. I cannot breathe free in the security of my own when theirs are insecure. And I say this as someone who is a tenured law professor. I think every day about what I am saying that could make me the subject of the Trump administration's attack and or my university terminating me. It doesn't stop me. I'm just aware of it all the time in a way that, in this case, I guess the in-group would be an ideological one that my conservative colleagues don't have to think about.
As a closing question, I'd be curious because part of this, yes, there's some scholars who will write on this, some litigants who can think about their strategies, and then there's just like the rest of us who are just normal people. Yeah. So how would you hope that our listeners think about using the First Amendment on a daily basis after hearing this, learning this, knowing this information?
Yeah, well, I'll just offer two closing thoughts because I know I've been running my mouth a lot and took you over time. So here's two. Kwame Nkrumah, the first black president of Ghana, is famously quoted by Fela Kuti and many other people as saying the following. The secret of life is to live without fear. There is no other way to live. Right now, there is a vast, monumental, chilling effect that is keeping tens of millions of us from speaking our mind, from advocating our causes, from attending protests, because we are afraid of the consequences. You cannot live like that. Claim the First Amendment, own it, use it, stand on it, defend it. And if there are consequences that follow, those are consequences we just have to bear. Okay? Again, I'll acknowledge, easy for me to say I'm a tenured law professor. Then again, several dozen tenured law professors have been fired from their jobs for saying the kinds of things I'm saying. So there's that. So the first thing I would say is that you should claim this First Amendment tradition as your own and demand the right to stand on it and exercise your right to free speech. The second thing I'll say is this is something that particularly is personal for me as part of my motivation for continuing to engage in this work, notwithstanding what might be some very real risks. I think of my right to freedom of speech as something that I don't own, but that is on loan to me. So for hundreds of years, millions of people who look exactly like me, along with their allies, fought, bled, died, and were enslaved until finally winning this right for people who look like us. I don't have the right to surrender it. It's not mine. I'm holding it to pass down. And so, whatever the risks, I can't give it to you. I cannot surrender something that I don't own. And so I would say understanding, I don't mean just like as an abstraction, but in reality, understanding what people went through to give me this right makes me even more determined not to give it to the government. I don't deny that they can take it, but they're going to have to come and get it.
Well, that is a perfect place to end. Thank you again for joining us, Professor Carter.
Of course.
Wonderful discussion. Reconstructed is a project of Douglas Collective, a 501c3 organization working to abolish injustice and advance the common good. If you enjoyed this episode, you can support our work by leaving us a review, sharing the episode on social media, or going to douglascollective.org/donate.